all that has been said in paragraph 5 in bracket 1 and in bracket 2 of the writ petition is that the respondent herein has been imposing and collecting various kind of direct and indirect taxes from the petitioner and other citizens of the country, that a part of the taxes so collected have been utilized for various purposes, including promotion and maintenance of a particular religion and religious institutions. Thus, it is nowhere mentioned in the writ petition as to what percentage of any particular tax has been utilized for the purpose of allegation in para 5 in bracket 2 of the writ petition is very vague. In our opinion, if only a relatively small part of any tax collected is utilized for providing some conveniences or facilities or concessions to any religious denomination, that would not be violative of Article 27 of the Constitution. It is only when substantial part of the tax is utilized for any particular religion that Article 27 would be violated, as pointed out in para 8 in bracket 4 in bracket 5 and in bracket 7 of the counter affidavit filed on behalf of the central government. The state government incurs some expenditure for the Kumbh Mela. The central government incurs expenditure for facilitating Indian citizens to go on Mansarovar, etc. Similarly, in para 8 of the counter affidavit, it is mentioned that some state of government provide facilities to Hindus and Sikh to visit temples and gurudwaras in Pakistan. These are very small expenditure in proportion of the entire tax collected. Moreover, in para 8 in bracket 3 of the counter affidavit, the central government has stated that it is not averse to the idea of granting support to the conducted by any community. In our opinion, we must not be too rigid in these matters and must give some free play to the joint of the state machinery. A balanced view has to be taken here, and we cannot say that even if 1 paisa of government money is spent for a particular religion, there will be violation of Article 27 as observed by Mr. Justice Holm, the celebrated judge of the U.S. Supreme Court. The interpretation of constitutional principle must not be too literal. We must remember that the machinery of the government would not work if it were not allow a little play in its joint. Hence, in our opinion, here there is no violative of Article 27 of the Constitution. There is also no violation of Article 14 and 15, because facilities are also given and expenditure incurred by the central and state governments in India for other religion. Thus, there is no discrimination in transport. This court observed that Article 14 cannot be interpreted by in a doctrine or dogmatic manner. Stop.